Hello and welcome to another fun video broadcast with Christopher Nudo. I am an attorney in the Chicagoland area. I have offices in Arlington Heights and Elgin, Illinois, and our practice focuses on estate planning. That would be wills and trust work, real estate, and other basic commercial transactions. The uniqueness of our practice is that we are Christian based with a Christ centered focus. And today I am really excited because I had the opportunity to pick a topic that I think is going to help people really understand the nuance between a will and a trust. Absolutely, the most often misunderstood concept is what is a will, what is a trust, how are they different, and which one do I need? And so today, by the way, there are many ways to answer those questions, but today we're going to take a very different approach, and an approach actually that is not often taken by estate planners, but definitely is applicable for today's topic. Also, I do want to take a moment and say the topics I'm going to be talking about today are Illinois law based. And so if you live in a different state, there's a chance that what I'm telling you is very applicable, but there's also a chance that there's some nuances and differences that doesn't make everything I'm saying 100% correct. So please, when listening to this video, understand that we are applying Illinois law. So how about we get started? I want to start by explaining that there are different bodies of law that govern different things. The one that I enjoy the most is if you've ever been on a cruise, the ship as it's leaving port and is in the water is governed by a body of law called maritime law. Now, what does that have to do with wills and trusts? Absolutely nothing. But it's kind of cool that ships have their own kind of law, right? It's a whole body of law governed for when they are out at sea. Well, it does actually have some applicability to today's topic, and that is that wills have a whole body of law governed by it. It's the Illinois Probate Act, and I like to refer to it as the body of law that's the testamentary law. These are laws specifically used to govern your estate if you die with a will and without a will. And it's just a body of law that governs what do we do with your assets, your estate, when you die with a will or without a will. Now, there's another body of law that's called contract law. Now, contract law seriously governs you from the moment you wake up. It actually governs you while you're sleeping. It governs you through your whole day. Matter of fact, contract law is so invasive in your life all day, every day, that most people don't even appreciate that they're surrounded by it. Let's use some examples. Well, at home, you have your electric and your gas company, your cable company, your internet provider, your email provider. All of these people govern the relationship between you and them with contract law. Testamentary law only governs your estate when you die. Note the differences here. Contract law is invasive in your life during your lifetime. Testamentary law, or the Illinois Probate Act, only affects your life after you die. Two important distinctions here. So, what are some nuances of the testamentary law, and why do we want to make this distinction between the Illinois Probate Act / testamentary law and contract law? Well, in the testamentary law, when you die, there's a certain set of steps that need to be analyzed to determine whether or not your estate has to go to probate. And in Illinois, probate is not a simple administrative function. It is extremely complex, has a lot of nuances, is very expensive. There is no abbreviated method of probate in Illinois like there are in other states. And this very complicated, extremely nuanced, very inefficient process costs a lot of money. And so when we look at an estate that is governed by the testamentary law, we need to first do an analysis to determine whether or not your estate needs to go to probate. Now, what are some of those factors that we look at when we're determining whether or not an estate has to go to probate? Well, the first factor is, what is the size of the estate? In Illinois, if the gross value of the estate is over $100,000, then the Probate Act would say that the estate should be probated. Now, for sure, there are some small little ways that we can avoid probate, even if the estate's over $100,000, but those loopholes are extremely small and narrow, and we're not going to get into them today. We're just going to go with the general rule, which is if the estate's over $100,000, then the estate has to go to probate. If it's under $100,000, then we can use a document called a small estate affidavit, typically, to avoid probate and still administer the estate in an efficient manner. Now, if you own a home and have a few bank accounts, having an estate over $100,000 is very easy, right? That's a really low threshold. And but what are some of the other factors that take us into the probate court? Well, one is you have a very extensive family. So if you have many children, or even a mixed marriage, or you have not just children, but you have grandchildren, and you might have deceased children. You may not have any children at all. And so now we need to look to see if you're married. And if you're single and you have no children and no spouse, now we have to look to see, are your parents alive? So these factors and the complexity in which your estate is in. Now, remember, when we talk about the complexity of your estate, we're talking about your life. How complicated is your life? And one does not go into their life with the idea that I'm going to make it simple or complicated. Life evolves and you end up at a certain state in life. And it may be simple, it may be complicated, but for sure, these are not the things and analysis that one typically perform. You wake up one morning and you either have nothing or you have stuff. And if you have stuff, the amount of your stuff and the impact your stuff has on your family defines the complexity of your estate. So we have the amount of your estate, we have the complexity of the estate, and then we have the type of assets. What are the assets that your estate needs to administer? If you are, lots of people like to invest in real estate. Nothing wrong with that. Being a landlord can be kind of cool. And when you invest in real estate, a lot of people don't consider what happens to these rental properties when we die. Let me tell you, if you are one of these people who don't consider your rental property and or real estate holdings from the standpoint of what happens to them when I die, then you will have a complex estate that needs to go to probate. Now, there's one other factor, and I've kind of skirted around it a bit. And but when you die with assets only in your name, then that is a perfect example of what we call a probate asset. So you have a bank account with $100,000 in it that's just in your name. That asset will become a probate asset. So we've been focusing on testamentary law right now. And I told you that we were going to compare and contrast that to contract law. So let's first define what contract law is. Contract law is a relationship between you and another party, and the terms that govern that relationship and the benefit that are bestowed between the two parties. I always think of my cable bill. So I pay Comcast. They provide me TV, internet, and phone. Great contractual relationship. I'm happy with the service they provide, and they're happy with the money I pay them. How does this pertain to your estate? Well, whether you know it or not, many people have their estates governed by contract law. Chris, give me some examples. Oh, I'm so glad you asked. Example number one, life insurance. If you own any life insurance, then that is a contractual relationship. Do you have a 401k? Oh, me too. That is a contractual relationship. How about an IRA, an annuity? These things are contract relationships. As a matter of fact, most retirement accounts are contract relationship. Your brokerage account, contract relationship. What is the unique nuance about these kind of accounts that make them function well in the contract realm? One thing, they all have the ability to name a beneficiary. So these accounts, when you name a beneficiary and you die, because of the contractual nature of the contract, that your asset now goes directly to the people you've named as a beneficiary. You're saying, but Chris, if I name people in my will, doesn't it automatically go to the people in the will? Probably, but because it's governed by the testamentary law, there's a good chance it needs to go to probate before it goes to the people you named in your will. Your will is not a contract relationship. It's a one-sided document giving direction. Now, let's tie this all together, shall we? One of the tools that is most often used in estate planning is a trust. This could be a revocable trust. It could be a living trust. It could be a revocable living trust. You're like, Chris, what's the difference? And I'm going to tell you, for the purposes of this, nothing. If you're on the West Coast, they call them settler trusts. If you're on the East Coast, it could be called a settler trust or a grantor trust. I've heard them called the loving trust. I think that's like a trademark name for a group that uses certain trusts. Why are all these names for all these different trusts, and are these trusts really different? And the answer is yes and no. They're different because trusts are as unique as the lawyers that are drafting them. But the overall purpose of all of the different types of trusts that I just mentioned is the same. And the purpose is to take your estate that is governed by the testamentary body of law and transfer it to the contract law. Why can a trust, what is the nature of a trust that allows it to be governed by contract law versus a will that gets governed by the testamentary law? Well, a trust has three parties to it. The first party is the owner, and that's often called the grantor or the settlor in these documents. The second party is the trustee, and the trustee is the person that's in charge of the trust. This is the person who has to understand what their job is to administer the trust for the benefit of the third party, and that's the beneficiary. And so the beneficiary is obviously the person who benefits from the terms of the trust and the assets that the trust holds. So if you have one of these trusts, you typically are the owner, the trustee, and the beneficiary during your lifetime, as long as you are competent. But when you die, you still remain the owner, but the trustee, the person in charge of the trust, transfers to somebody else, because governing your trust while you're dead is quite impossible. So another person must take over your trust. But that new person, called a successor trustee, is working for the benefit of who? The beneficiary. Now, the successor trustee and beneficiary can be the same people, different people. It depends on your trust. It depends on your estate. Obviously, if you have young children, your successor trustee will not be the young children. It will be a competent adult that you've chosen to administer the estate for your children. However, many people who have adult children, 30, 35, 40, older, not younger, and these children have demonstrated that they can appropriately manage finances and be mature adults. Well, many parents will make those children the successor trustees and the beneficiary. So that's an instant where they're the same. Now, remember, I explained to you under contract law, there was a relationship between many parties. And so you can tell by my previous description of a trust, we have this relationship between the owner, the trustee, and the beneficiary. I understand that while you're alive, it's kind of like saying me, myself, and I, or because you are all three roles in the trust. But when you die, you see that the roles are more clearly defined when the trust then has different people as the owner, the trustee, and perhaps in times the beneficiary. Now, why is all of this so important? Well, the reason is contract relationships that have beneficiary, whether it's your life insurance, your 401k, your living trust, anything where there is this owner, manager, and then beneficiary type of relationship. All of these in the contract realm avoid probate. Whew. That was a long way to get around to explain the fact that these contract relationships avoid probate because probate probate's only in the testamentary body of law in the Illinois Probate Act, governed by your will or an estate that doesn't have a will. As soon as you move your asset from the testamentary body of law over to the contract body of law, and we do that using trusts and other vehicles, life insurance, annuities, 401ks, IRAs, brokerage accounts, specifically designed money markets and or savings account. All of these things, when beneficiaries are attached to them, remove the asset from the testamentary body of law over to the contract realm and avoid probate when you die. Now you're saying, Chris, I think that's clear. I think what you're trying to tell me is I should do an analysis of my estate, which is all of my assets, and I should determine which assets would be governed by the Illinois Probate Act, the testamentary law, and which assets are governed by contract law. And that is correct. That is the analysis. And what we want to do at a minimum is design an estate plan that removes all of the assets from the testamentary body of law, the Illinois Probate Act, and move them to contract law. So that when you die, whether it's your spouse, children, nieces, nephews, aunts, uncles, parents, whoever, best friend, all of these assets get transferred to them with the avoidance of probate. That is the essence of a good estate planning analysis. Now, there is so much more, so much more that we could talk about here, but I just wanted to take this time and just describe the Illinois Probate Act, the testamentary body of law, and contract law, and why the two are distinct and different, and why we want to remove your assets from one and put them in the other. This analysis could go much deeper. We could talk about so many other things that pertain to trusts and their benefits that they provide. And so many people, when I explain this to them, they say, Chris, does that mean that there's never a time that a will it can be used? And that is not true. There are many, many instances where having a simple will is a wonderful vehicle for helping administer your estate when you die. However, I gave you earlier a little bit of the analysis that we like to do with regard to the complexity and the size of your estate. And when the complexity and the size of your estate meet that certain threshold, then a will is no longer the most efficient tool, and we should move your estate to the to the contract side of things using a trust or other instruments that have a beneficiary designation. Now, while I was going through all of this, several questions have come in. So let's do a quick recap here, answer a few questions, and then be done for today. First of all, again, my name is Christopher Nudo. I'm an attorney serving the Chicagoland area, and we serve in estate planning, real estate, and other transactional forms of law. Did I say that we have offices in Arlington Heights and Elgin? I think I did a couple times, but just in case you didn't hear it the other time. So, oh, by the way, you really should go back and look at my video that I did last time, which was the benefits and nuances of estate planning for police officers and other first responders. If you are a first responder, first of all, my heart goes out to you. Thank you so much for your service. But second, please take a look at it. Or if you know somebody that's a first responder, please share the video link. And I just think it would be a blessing to them to understand estate planning from their perspective. Now let's move on to a few questions that came in. Like always, the questions are just unbelievable. We really appreciate you taking the time and entering them. It says, what type of trust is best for someone who doesn't have any children? Well, excellent question. One of these grantor trusts, living trust, revocable trust, remember I said that they're all the same thing. A trust that ensures that we've removed your estate from the testamentary body of law over to the contract law, and that makes sure that we've appointed a very accountable and responsible adult to manage your affairs, to transfer your assets to your nieces or your nephews or your brothers, sisters, girlfriend, boyfriend, parents, best charity. These is the type of trust that we want to use. It doesn't have a specific name. Like I don't have like the single person's trust, but it is the essence within the trust that that we design that really will benefit the single person with no children. Great question. Thank you. Second, let's see. Can I designate a beneficiary that is not my child, such as a second spouse or a family member? I think I just nailed that in the previous question. The answer is of course. Children do not have an entitlement to your inheritance. They often think they do, but they do not. And so you using your newly drafted living trust can specify charities, churches, other family members, friends, your pet, by the way. That's a big one. Let's make sure that Fluffy is taken care of when you die, because you know what? Fluffy's every bit as important to the family as sometimes the children. As a matter of fact, dare I say that some parents treat Fluffy better than the children? I don't know. Suppose I've said it already. What if I have children from two different marriages? How would I handle the distribution of assets? Ooh, a complicated question. Well, there's no chance I can do this question thorough justice right now. This could be a whole topic for a video. But if you have children from different marriages, which by the way is extremely popular, then we need to do what is termed advanced estate planning. We really, really, really want to make sure that both children benefit from your estate, and that no unintentional consequence comes where one or both of your children become disinherited because they come from different families. And let me tell you, it is actually easier to become unintentionally disinherited when you are have a blended or mixed family from multiple marriages than it is for your estate to transfer to your children directly when you die. So that's why we call it advanced estate planning, because truly it takes a lot of thought and nuance and specific provisions to ensure, to absolutely make sure that your children don't get unintentionally disinherited. Great question. Small answer, certainly not adequate. But let me just finish this answer by saying, if you have a mixed marriage, please make an appointment with an estate planning lawyer who understands the nuances of this specific advanced planning so that your children are well taken care of. Let's see. Next question. If I'm a business owner, should my business be owned by my trust? The answer is yes. Why? Because if you own your business and you die, your business is a probate asset. There is no relationship. So we need to transfer the ownership of your business to your trust. Now we have that relationship because of the beneficiary trustee relationship. So absolutely, if you own a corporation or an LLC or any kind of business, we want to make sure that entity is not a probate asset when you die, but rather controlled by the contract law. And so we want your trust, we want your business to be owned by your trust. Let's see, what do we have here? I love the questions that could be a whole segment on their own. And that would be our next question. Are there any tax advantages lawyers know about that everyday people do not? I would say for sure, but we're not going to get into those right now. And whether or not those tax advantages are applicable to your estate or not would require an analysis. Again, what a wonderful reason to make an appointment with a talented estate planning lawyer who can walk you through those various tax advantages that may or may not apply to your estate. How much does it cost to work with an estate planning lawyer? I like to answer that question by saying this. How much will it cost for you or your loved ones if you don't plan properly? We have this saying here at the office, and that is that friends don't let friends play stunt lawyer. There are certain things that do-it-yourselfers can do, like, hanging some cabinets, putting up some pictures. Maybe you're really talented and you can do some carpentry, some plumbing, some electrical work. Yeah, but estate planning's not necessarily the do-it-yourselfer kind of thing, despite the fact that there are a number of websites out there that claim that they can help you do it yourself. So I ask you, do you want your assets to be transferred to the people that you intend them to go to, or are you willing to risk the chance that the documents you did on a do-it-yourselfer kind of way fail and your estate doesn't get administered the way you thought it was going to do? Working with an estate planning lawyer is expensive. I'll just say that. And expensive is relative to a lot of people, but it's going to cost $2,000 to $3,000 to $4,000 depending on the complexity of your estate. Let's see. Do you offer? I love this question. Comes up very often. Do you offer virtual appointments or on-site visits? Yes, I do. So listen, virtual appointments, they're nice, and I have designed some magnificent estate plans for people who I have met only virtually. Honestly, my preference is to meet you in person, but I do whatever you're most comfortable with. So if you want to do a phone call, if you want to do a virtual meeting using interactive video like this, or if you want to come in and visit me face to face, I offer all of that. And my job is to work for you. And so whatever is most comfortable for you is what I will do for you. All right. So that leads us to, where can you contact me for a consultation? On the screen below, you're going to see various contact information, from addresses to phone numbers for your ability to text me, call me, text, I often say if I could read smoke signals, you could put a bonfire up and I'd respond, but I don't know how to read smoke signals. So let's pass on that one. Any way you want to contact me, go for it. Email is probably the most common, but we have a generation of folks coming up where text message is their preferred method of communication, and I'm very cool with text messaging as well. By the way, I like to say my favorite form of communication is the telephone. I love talking to people. I don't know what it is today, but we carry our smartphones around and so many don't even use them for phone calls. I understand that's generational. That may show my age. So does the gray hair, the receding hairline on this side. What are you going to do? We're all different. I want to really thank you for joining me today. It's been my privilege to be able to share with you this knowledge. Hopefully you gleaned something, just a little bit, from what I had to say. It's my heart that the knowledge that the Lord has blessed me with, I can impart a little of that on you, and that that little impartment of knowledge you can embrace and make your life better with. Like everything in life, this estate planning process is a process and it takes some time. Don't procrastinate it, please. Make a plan, get started, make an appointment, and get it done. It's really important. You cannot go back and do it after you've died. I know that sounds so ridiculous, but it's the truth. Get it done before you need it, because when you need it, it's always too late. So I invite you to see me back here next week on our Facebook Live, Fridays. I try to do Fridays 8:30 Central Time. You will find that I'm not necessarily right on time or punctual, but you know what? We will all work together and get this done together so that we can all enjoy the information. Please feel free to invite your friends, share our recordings with your friends and loved ones. And I just want to say, may the Lord be with you this week. Have a great week. Take care.